Agency for withdrawal. Tomorrow.
The senior citizen said, rather than obtain the protection, such as preferred the petition for status quo order. Probably 84 years old father
Thrown out.
is from the house. And he is harvesting the crop of the father. It is pending.
Tomorrow. Told.
This is a matter pertaining to the election commission, wherein I am the petitioner and I am the political party, and my party has not been registered, despite complying everything. So kindly have this matter posted to Monday.
There's no elections, nothing. It will come next regular course.
Member for withdrawal, my lord, for 230. My lord, the urgency is, my lord, we have challenged only Panchanamas, my lord. Now they are issued.
Tomorrow. Withdrawal will come tomorrow.
My lord, please, my lord, I travel from Dharwad, my lord, for withdrawal. I travel from Dharwad.
You don't. Why did you travel from Dharwad? You can come from one VC.
Please, my lord.
You wanted to come and see Bangalore.
My lord, I am.
Please.
My lord, I am appearing.
Yes.
Please, my lord.
One matter for 230, my lord. It's an emergency parole, my lord. He had directed on an operation on 24th, my lord.
At 2:30, it may be taken up, my lord.
Since he's been convicted on one case, my lord, we'll have it on 230, my lord. Empty of plastic, my lord. Empty of plastic. Left ear's surgery. He's been infected, my lord.
So what is the urgency for 230?
My lord, emergency parole. He has to get operated on 24th.
It will come.
On the Bonaparte particular, in the initial charge sheet, I was arrested as a witness. Now, Manaship, police has issued notice on that. 35 class 3. Without taking any further
It's only a notice for inquiry.
Charge sheet already been filed. Without taking further permission from the
It's good.
Lord, may I make submissions, my lord? Lord, may I make submission, my lord?
33. I'm filing.
Just a moment.
My lord, this matter is pertaining to parole, my lord. This matter was listed on 12th, my lord. And on the 12th, there was not a parole day matter. On this honorable court was not taking parole matter, my lord. So I have sought for adjournment, my lord, and this honorable court has given date on 19th, my lord. By oversight, my lord, this matter is adjourned to 17/9.
27/8.
Tender matter. I moved this matter yesterday and day before.
Have you complied with everything?
Both days are not selected to post the matter for yesterday and today. Both days not listed. Tender matter.
Fresh matters ಯಾಕೆ ಬಂದಿಲ್ಲ ಇದು? Fresh matter.
Please,
2 days mentioning and 3 days ಆಗೋಯ್ತಲ್ಲ. Fresh matter. 230 thought. 230.
Lordship, this is for being spoken to. The Lordship has allowed the matter to be listed on Monday, but the file was not there in both branch. It was now disposed matter. The WP has been disposed, taking I have statutory provision under arms. But what we have challenged in WP is the arms.
You had mentioned this earlier also. Monday thought.
My lord, withdrawal for Monday, my lord.
Withdrawal for 230, my lord.
Pending matters, we will not take it up at 230. Even for withdrawal, the other side has to be notified.
For withdrawal, it's a petition, my lord. It's a liberty to challenge ECR proceedings before the.
If the other side has any objections,
No, my lord. Why they have an objection?
tomorrow,
My lord, emergency parole. At least short.
27th.
Monday, my lord. 27th operation.
There is no urgency in what you are saying. Yes. You had moved this yesterday. Tomorrow. Yes. Tomorrow. Tomorrow.
My lords, this is a writ petition challenging section 34 proceedings, my lords, which are belatedly initiated. It's covered by your lordship's judgment itself, my
The
lords.
fresh matter, pending matter.
No, my lords, pending matter, my
Pending
lords.
matter will come in seniority.
My lords,
Challenging the validity of the marriage, online register.
Challenging the
Nullity of marriage.
nullity of marriage in a writ petition.
Yes, my lord. The online registration has been taken. Marriage has been registered through online, my lord, by using the fake Aadhaar of the petitioner, my lord. That is why.
How will we determine that in a writ petition?
Previously,
Monday third.
My lords, list number 1, serial number 33. I'm filing memo of withdrawal, my lords.
Just wait until we told you again. Yes.
Fresh
Sorry,
matter.
madam.
I'm practical, sir. My
Yenappa?
other friend is the head of
Fresh matter pending.
fresh matter, my lord. This is the tender matter. Nandini booth is running, my lord, now. Now the tender has been called. They are now going to evict the petitioners.
Your term is over.
ಅಲ್ಲ ಟರ್ಮ್ ಅಂದ್ರೆ ಇದು ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ ನಾಳೆ ಪ್ಲೀಸ್.
If your term is over, we'll direct them to immediately evict you. Have you complied with all the office objections? Yes. ಇದಕ್ಕೆ ಮತ್ತೆ third time memo ಬಂದಿಲ್ಲ. Fresh matter. Old matter, you move 100 memos, it won't come. Keep it with you only. It'll come in seniority. It'll come in seniority. There are a lot of other people waiting before you.
Pending matter for withdrawal. For withdrawal.
Tomorrow.
The predicate offense, Lord, the petitioner, Lord, who are the family members who have been dropped in the charge sheet. Lord, subsequently, Lord, as against the principal accused, there is a stay by this honorable court, Lord. Now, the family members, Lord, whose mother, who is aged about 73 years, Lord, has been summoned by the PD. There is urgency.
Fresh matter.
Fresh matter.
Tomorrow.
Petitioner is student seeking change of name. Respondents have all been served. Heard and disposed.
Pending matter, we can't make exception for anybody, please.
Go abroad to study. Tomorrow.
If you make one exception, somebody else will stand and say, make exception for us also. Now, where is he going to go abroad? The term is in next year.
Last semester.
Still time is there. Yes.
For adjournment.
Fresh matter. Challenging externment notice.
Tomorrow.
Adjournments. List number 1, page number 6, serial number 38.
Your Lordship, serial number 42.
Not called out as it, madam.
Page number 7, serial number 39 to 44.
Yes.
Serial number 42, Your Lordship.
Serial number 39.
Kindly given a 1 week time, my lord. Senior is not given.
You are for?
Respondent number 2 to 5, my lord. 39.
Yes.
Matter is for urgent, my lord. Maybe posted on Monday for 2:30 matter.
Adjournment will be only end of September.
There is an urgency.
So it's going to be adjourned, it will be adjourned to September, otherwise we won't adjourn, whatever you want.
I object for adjournment.
You object. Ask her to come and VC, madam.
My lord, serial number 33.
33.
I'm filing memo of withdrawal, my lords.
33
I filed the
memo of
necessary
withdrawal,
application
dismissals withdrawn.
before the magistrate court. Liberty may be granted.
Liberty for what?
If in case the application may in unforeseen circumstances be rejected, my lords.
That is a fresh cause of action. You can always file.
Grateful.
Serial number 42, Your Lordship. Appearing for petitioner.
40?
42, Your Lordship. Senior
Yes.
is having some personal inconvenience. Any short
42 are
accommodation?
the request to counsel for the petitioner, 23rd September.
Much obliged, Your Lordship.
Page number 8, serial number 45 to 48. Page number 9, serial number 49 to 53. Page number 10, serial number 54 to 57. Page number 11, serial number 58 to 63.
61, my lordship. I'm for the respondent. I have duly informed the petitioner, my lordship.
61 at the request of counsel for respondent number 1, 23rd September.
Yes.
Page number 12, serial number 64 to 68.
Serial number 64, Mila. The meeting is called between the Horticulture Department and the Revenue Department. This is regarding the
Bus stand.
bus stand code is on the otherly, in fact, the association is also called for the meeting. Your Lordship may kindly have it after 2 weeks, Malad. There
You
will
are
be
for
some-
whom?
I'm for association. Together.
Association.
For the advocate.
Who is appearing for the bus stand?
Bus stand illa, it's only the horticulture department which has to give away the land over there. Regards to posting.
Horticulture department alwa.
Illa, sir.
Your Lordship may have it after 2 weeks, Malad. There will be some development.
He is coming forward. When are you going to give the space? We will have to shift the bus stand.
Illa, I was told that in this session itself, there may be chances.
Yesterday, Shamant made a submission that he had gone there And his submission was that the place is horrible.
2 weeks time we are seeking from the behalf of the association. In the government level,
The word used was horrible.
it's true, my lord. In fact,
How is it? Good, better, better, horrible. And you can't be sitting on this like this. Litigants are coming. 2 weeks time is sought for. Respond. Horticulture department is directed to expeditiously look into the matter and do needful. Otherwise, necessary action would have to be taken to shift the bus stand from the present location. Released on 7th September.
Great.
Page number 13, serial number 69 to 76. Page number 14, serial number 77 to 79. Page number 15, serial number 80 to 86. Page number 16, serial number 87 to 94.
Lord, serial number 91, madam. For the petitioner, short accommodation.
91 at the request of petitioner, 23rd.
Page number 17, serial number 95 to 101. Page number 18, serial number 102 to 108.
This is with regards to posting memo. I was late for 2 minutes. This honorable court had passed a direction to the passport authority to release my passport. I had applied for SVP. They have released my passport, sent through Indian Post, taken it back, telling that I have not given an order from the Hyderabad court. Now I have already placed the order before them 6 months back. Now I have my travel dates. I filed a fresh petition for release of my passport. Tomorrow. Much obliged.
List 2, serial number 19, my lord.
List 2, serial number 19.
General Parole. Special case to judgment copy next week.
List 2, serial number 19.
19, my lord.
Parole matter. Huh.
Parole memo. A special case to judgment copy next week.
19 at the request of counsel for the petitioner, released on 27th August.
With the permission of the court, serial number 20 in the first list. Tomorrow, please. The counsel on record, he met with a small road mishap. So its urgency is that my portal is blocked by the education department to upload the details.
The request of counsel for the
Tomorrow,
petitioner,
please.
Monday.
No. They have fixed the 21st as the last date. Tomorrow. Please.
Tomorrow.
Please.
Serial number 9, list 1.
Serial number?
Serial number 9. One.
Yes.
There is some mistake in the property description. So we require some time to file IA for amendment.
9 at the request of counsel for the petitioner, seeks for and is granted 3 weeks time to file an amendment application, released on 16th September.
My lord, serial number 107 in list 1, my lords. It's regarding passport, my lords. Very same matter was dealt last week, my lords. Very same thing was dealt with last week. Same facts, my lords. The other case was allowed, my lords.
You can't mention it like that.
My lords, the issue is, my lords, it's been listed in B group, my lords. It was listed before coordination.
List number 1, fresh matter, serial number 1, Ananda Hedge.
Petitioner Malad being agreed by the decree passed by the Lok Adalat Malad has preferred this petition Malad. The Malad tracks Malad. The petitioner father.
Where the plaint?
Plaint Malad, Annexure Malad, D Malad.
Page?
Page number 45 Malad.
45.
45 Malad, Annexure B.
Rudramma.
Ratnamma is my elder sister Malad. She filed a suit for partition and separate possession only against brothers Malad. Venkateswamy Reddy is my elder brother. Sujata, Praveen and Manshi and Reddy are the wife and children of my another brother A. Nagaraj. And Malad, Amrish Reddy and Prasanna, different number 5 and 6 are my brothers, younger brothers Malad. Without making me as a party to the said suit Malad, she filed a suit for partition and separate possession. And in the said suit Malad, as per Annexure B, they filed the compromise petition within 4 days from the date of filing the suit and was
issue notice to respond number 1 to 11, written up by 28th September. The petitioner also claims to be the family member of respond number 1 to 10. Respond number 1 had filed a suit in OS number 1198 of 2019. on 5/12/2019 for 5/12/2019, which came to be registered on 10/12/2019 for partition. They said suit came to be compromised among the parties on 14/12/2019 without a share being allotted to the petitioner, since the petitioner was not a party to the said suit. Hence, the compromise decree drawn up in the Lok Adalat in OS number 1198 of 2019 on the file of the senior civil judge and JMFC Anekal, Bangalore Rural District, he stayed till the next date of hearing. Process fee and copies to be furnished by end of day 20th, failing which the interim order will stand automatically vacated.
And also, my lord, permitted to take out hand summons, my lord.
Counsel for the petitioner is also permitted to take out hand summons on the respondents, as also serve the counsel for the respondent who had appeared in the trial court.
Serial number 2, Ravisha MG.
The petitioner seeking mandamus in respect of annexure A and B is for this petition, my lord. The annexure A is made a representation to the sixth respondent, since the husband of the first petitioner and father of petitioner number 2 and 3 died due to the agrarian debt. Till today, they have not been responded.
You will accept notice for respondent number 3, Ms. Jaffer?
My lord, this petition shows only state of Karnataka.
State of Karnataka.
3 and 5 are up here.
5 sir.
Pandopura Subdivisional Level Verification Committee. Will the state appear?
My lord, the state appears, my lord.
And AGA for respondent number 127. Petitioner is before this court seeking for the following reliefs. The petitioners are the wife and children of late Devraju, who was an agriculturist. He having borrowed loan for agriculture activities due to loss of crop, he committed suicide on 1/12/2022. In that view of the matter, the petitioner had made a representation cum application on 5/3/24 to the seventh respondent for grant of compensation as per the scheme which had been announced, as per the government scheme for farmer suicide, accidental death or snake bite announced by the state. The said representation not having been considered, the petitioner is before this court seeking for the aforesaid reliefs. When a scheme has been announced by the government and an application is made in terms of the said scheme, it is but required for the said application to be considered as per the terms and conditions of the scheme and processed as expeditiously as possible, since non-processing of the same would render the entire scheme otiose and would only amount to a window dressing. In that view of the matter, the application having been filed by the petitioners on 5/3/2024 could not have been kept pending for more than 2 years as done in the present case, especially when there is a death in the family of the petitioners, as regards which a scheme for compensation had been announced by the respondents. In that view of the matter, this court passes the following order. Writ petition allowed. Respondents are directed to consider the application cum representation of the petitioner dated 7/2/2023 at Annexure A and 5/3/2024 at Annexure B, and pass necessary orders within a period of 30 days from the date of receipt of a copy of this order. The first respondent is also directed to look into the matter and establish a necessary system for consideration of applications under various schemes formulated by the government coming under his department to ensure that the applications are considered in the time-bound manner. Insofar as the present case is concerned, the first representation having been made on 7/2/2023, which has been pending for more than 3.5 years, respondent number 1 is also directed to take necessary action against the concerned officers who are responsible for the said delay. Either Sakalal Baral Wala. Respondent number 1 is further directed to consider the inclusion of the implementation of various schemes under the Sakala so and so Act with a time-bound disposal of the said application.
Much.
Serial number 3, B.S. Ivan Kumar.
Transfer of authorization and a compassionate ground. Page
Compassion.
number 15 is the author.
Rejected on what ground?
Well, it's rejected on the ground of age of the deceased and
71
10th
years.
standard Mulots.
Inna policy bandilla. You won't come up with it at all.
Section 13 is clear. Section 13, 65 years.
And AGA for respondent number 1 petitioner is before this court seeking for the following leaves. The husband of the petitioner was granted a authorization to run a fair price depot at Wullardi village. When was he granted?
Mulots, it was granted in 1993-94.
In the year 93-94, which has been renewed from time to time and is now in force until
Till 2018.
till 2000
2028. I'm sorry.
28
2028.
till the year 2028. Unfortunately, the husband of the petitioner expired on 19/4/2026. Hence, the petitioner made an application for transfer of authorization on 30/5/2026 on compassionate basis. The said application came to be rejected by respondents on the ground that the husband of the petitioner at the time of his expiry was more than 65 years.
And she doesn't
On
qualify.
that, she did not have a qualification of 10 standard. This court, it is challenging the same that the petitioner is before this court seeking for the aforesaid reliefs. This court in a catena of decisions has held that it is the age of the transferee which is required to be considered for the purpose of transfer on compassionate basis. Has also held that the education qualifications are not applicable to a transferee on a compassionate basis. This aspect has been given a go-by by the respondent while considering the application made by the petitioner. Hence, this court passes the following order. Writ petition is allowed, a certiorari is issued. The endorsement dated 24/7/26 issued by second respondent at Annexure C is quashed. The mandamus is issued directing the response to consider the representation stroke application of the petitioner dated 30/5/2026 at Annexure B as per the observations made here and above without insisting on the 10 standard pass certificate and transfer the authorization within 30 days from the date of receipt of a copy of this order, subject to the petitioner complying with, within 30 days from the date on which the petitioner has complied with all other administrative requirements, including furnishing of no objection from the other family members, as also submitting indemnity and undertakings as required.
Much.
Serial number 4, S.R. Sriprasad.
A is question, Annexure A, the cancellation of the caste certificate of the petitioner on the ground that the school records of the petitioner,
Yes.
at page number 14.
What is the caste?
His caste is Channadasar.
Scheduled caste?
AK antana ide. AK and Channadasar both come under scheduled caste.
Scheduled caste. Mr. C. Jagdish is directed to accept notice for respondent number 1 to 5. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. Relist on 10th September.
Lord, interim order, start first. Cancel.
How can we grant interim order without hearing?
Please.
Serial number 5, Naveen Jain.
Yes, Naveen.
Appear for the petitioner. Lordship, kindly see the Annexure A, page 38, Your Lordship. It's the tender, my Lordship, invited by the government. Lordship, this is on 19/12/2016. Your Lordship may come to page 102, Your Lordship. 102.
102.
Please, Your Lordship. Lordship, the arbitration clause at 7.2, Your Lordship.
Yes.
Lordship, thereafter, my Lordship, the tender was awarded in my favor, page 124, Your Lordship.
Any dispute? What is?
Lordship,
This is
dispute.
arbitration clause alive. This is a dispute settlement.
Dispute settlement. Lordship, the tender is awarded in my favor on Lordship, page 124, Your Lordship, Annexure B. Thereafter, it was extended. Lordship, certain disputes were arisen. Lordship, page 182, Your Lordship, Annexure G. The matter was referred to arbitration.
Referred to arbitration.
Please, Your Lordship.
With consent.
With consent, Your Lordship. Thereafter, my Lordship, page 213, Your Lordship, another arbitration was referred. 213, Your Lordship. The dispute in
Another
respect.
arbitration, Andre?
Another, my Lordship, the dispute in respect of certain payments, Your Lordship. The government has withheld certain payments. Hence, my Lordship, matter was referred to arbitration and it was awarded. My Lordship, kindly see, one of the award is at page 209, Your Lordship.
Yes.
As a claim petition is allowed and the claimant is entitled for so and so, my Lordship. It is one of the award. It became final.
Yes.
The second award also became
No
final.
challenge was made on 34.
Please. Second award also become final, Your Lordship. Page 213, it was also become final. Lordship, thereafter, Lordship, I issued a notice at page 249, Lordship, for a moment. Lordship, for certain amounts, that is page 249, Annexure M. That is on 27/5/2006. Call for arbitration to settle the dispute of short payments of service of rupees so and so. It is one of the notice. This is in respect of one claim, and another notice at page 253, Your Lordship. This is in respect of 76 lakhs, Your Lordship. Two notices have been issued, Your Lordship. For this, my Lordship, they have given the impugned communications, page 257 for a moment, Your Lordship. That is on 16/7/2026. Your Lordship may come to last paragraph. Moreover, the government of Karnataka Law Department has also, in its circular dated 16/11/2024, incorporation of arbitration clause in the government contract tenders has been withdrawn with immediate effect, and it is further instructed to delete the arbitration clause from the existing contract tenders after discussing and obtaining consent from the concerned parties to the contract tender. In view of the terms and conditions of the contract dated 18th March 2000 cannot be invoked.
If you want to initiate arbitral proceedings, go under section 11. Why you filed a writ petition?
Lordship,
That court will decide it. But as it is, there is no arbitration clause.
My submission is, Lordship, the notification is at Annexure K, Your Lordship, for a moment.
Mr. Naveen, the clause that you have pointed out doesn't have arbitration in it. That is why we asked you at that time only, without getting into all.
It is for the dispute.
There's no arbitration clause. With consent, if they had done it at that particular point of time,
yes,
you can't force the consent subsequently.
My submission is, Lordship, kindly see the Annexure K.
Again, section 11 ಆಗ್ತೀರಾ dismiss ಮಾಡೋಣ.
ಆಗ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದೇ ಒಂದು submission ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ನೀವು submission ಮಾಡಿದ್ರೆ we'll deal with it. Whatever submission, we'll deal with it.
No, Lordship, that is not my intent. I'm only pointing out, Lordship, if the notification was withdrawn in the year 2024, they have participated in the arbitration proceedings in the 2026, and they have
already
not
initiated. They can't stop in between.
Please. That liberty,
initiated, they can't. What do you want to do?
The liberty, my Lordship, to file an application.
You're withdrawing.
That liberty, my Lordship.
And AG accepts notice.
All the respondents.
For respondents, petitioner is before this court seeking for the following leaves. After arguing for some time, learned counsel for the petition seeks permission to withdraw the above petition with liberty to file an application under section 11 of the Arbitration Conciliation Act 1996, preserving such liberty, leaving all contentions open. The petition stands disposed.
Serial number
26 stands disposed.
K. Chandranath Ariga.
Yes, Mr. Ariga.
Yes, my lord, kindly recollect. Yesterday, I pointed out
for the order sheet
about
annexure matter not reached.
Annexure A. A submission was made by me that on 8/7 annexure A.
Yes.
8/7/2026 there was no sitting.
No sitting.
Therefore,
there was no sitting, my lord, but open court he has passed 6 orders, my lord.
How can he pass orders when there is no sitting?
Regular sitting was not there, my lord.
If there is no sitting, how can orders be passed, madam?
My lord, there were two separate cost lists, my lord. One was for the hearing, one for the pronouncement of orders, my lord. He has adjourned all the RDP matters.
Hearing is different from having no sitting.
No, my lord. There was sitting, but he has not taken up any RDP matters. He has just pronounced the order and then he has left, my lord. For other matters, he has not taken up. He has adjourned it, my lord.
Not the way to be done.
Only he sat for the pronouncement.
If tomorrow we say no sitting and will come and pronounce orders, he'll notify no sitting.
My lord, the notification on the WhatsApp, it clearly says all the RDP matters are adjourned, my lord. This is a separate cost. I'm submitting the separate cost list. Because here only 6 matters were listed only for the orders, my lord. The notification which they submitted, my lord, it says all the RDP matters, no sitting.
ಮತ್ತೊಂದು
9 ಮಾಡಬೇಕು 9 ಸೆಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ ಅದ್ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕ ನಾವು ಈಗ
Where is the RDP list?
I don't have that, my lord. It's a separate list. It's put in the WhatsApp also, my lord. And that WhatsApp group is, my lord, it's an unofficial group, not an official group by the department. It is only for the convenience of the advocates, my lord.
Who posts messages on it?
The caseworker post the messages,
Then
my
it is
lord.
official.
Because sometimes the sitting will be cancelled, so that's.
You are posting, it's a good thing that you are doing, but take responsibility for it. You post it again and pass the orders. This order will recall.
ಸೆಂಡ್ ಮಾಡ್ತಾರೆ
After saying no sitting, orders cannot be.
My lord, the notification says all the RDP matters are adjourned, my lord. No hearing for that matter because it's.
Then you should have said there, ADM list will be taken up.
ಸ್ಟೇ ಇತ್ತಲ್ಲ ಅಲ್ಲಿ
Should be clear in your communication.
Because the communication also says today RDP matters, my lord. RDP cases, no sitting.
Now you have another sitting and pronounce the same order. Technicality, but judicial discipline or quasi-judicial discipline also requires that to be followed.
Yes.
You can't have saying that no sitting and then pronouncing an order. And please instruct your, they don't know how to conduct the proceedings, so they get into this kind of trouble. They are not attributing any malafide, but
yes,
should not do this.
Yes, ma'am.
Permitted to appear for respond number 5. So he has produced page 118, of the WhatsApp status, wherein it was stated that Madam today RDP cases is not.
But nobody told them that this will be taken up.
All the 5 cases were pronounced, Your Lordship.
If there was some submission to be made, you could also be on this side, Naveen. This is for the system and the institution, not for individual matters.
ರಿಸರ್ವ್ ಆಗಿರೋ ಕೇಸ್ಗಳು ಪ್ರೊನೌನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಬೇರೆ ಕೇಸ್ಗಳು ಸಿಟ್ಟಿಂಗ್ ಇದೆ
ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಅದನ್ನ
That
ಹೇಳಿದ್ದಾರೆ
will be taken up and this is the only thing.
ಪೇಜ್ 118 ಅಲ್ಲಿ ಹೇಳಿ
ಇದೇನು ಬೀಸೋದೊಣ್ಣೆ ತಪ್ಪಿಸ್ಕೊಳೋದು ಅಷ್ಟೇ. Next week he'll pass the same order. But it should be done in a proper manner. And AGA accepts notice for respond number 1 to 4. Shri Nitin M, who has filed caveat, accept notice for respond number 5. Petitioner is before this court seeking for the following reviews. The petitioner is aggrieved by the impugned order dated 8/7/2026 at Annexure A. The submission of Shri Chandranath Ariga, Land Council appearing for the petitioner, is that in the WhatsApp group, though unofficial, on which the caseworkers post messages informing all the lawyers about the holding or not holding of sittings and such other communications as may be relevant to the stakeholders. It had been communicated that there would be no sitting on 8/7/26. And on that ground, he submits that there could not have been an order pronounced on 8/7/2026. The submission of learned counsel for respond number 5, as also learned AGA, is that the communication which had been posted on the WhatsApp group was that RDP cases, there would be no sitting. It is for that reason that is on that basis that they contend that the said message would not apply to ADM cases which were separately listed for pronouncement of orders. The message which has been posted on the WhatsApp group, though indicating that RDP cases no sitting would be there, there is no specific reference that for the other matters there would be a sitting and the matter would be taken up. It is required for all communications addressed by the quasi-judicial authorities to be clear so as to enable the parties to understand the said message and do the needful. Though it could be contended that the setting aside of the order would be empty formality inasmuch as the first respondent could again post the matter for orders and pronounce the same orders. What is required to be considered is that when things are required to be done by judicial or by quasi-judicial authorities, it should be done in that particular manner. Once information had been communicated that there would be no sitting, there could not have been a sitting held and the order pronounced. As such, this court passes the following order. Writ petition is allowed, a certiorari is issued. The order dated 8/7/2026 at Annexure A and the consequent direction of 8/7/2026 at Annexure A is quashed. It's made clear that this court has not expressed any opinion on the merits of the matter. It would be for the commissioner to post the matters on the date on which a sitting is there and to pronounce such orders as he wishes to pronounce.
Fix a date, Your Lordship.
We can't fix, let him fix.
My Lord, may I
That is the whole problem that has happened and you want us to fix now.
My Lord, may I request for an opportunity to be given?
Once it is posted for orders, if you want recall application, you file it. If it's permissible, they'll consider it.
My Lord, there is another issue on merits. I would have otherwise submitted before this.
Mr. Ariga, then you submit on merit, then we won't consider your technical argument.
No, therefore.
And then we'll consider it on merits only. You make your submission, Ms. Naveen will also make his
This
submission.
was apparent on the face of the record. That's what I placed before the
That is why we
honorable
are
court.
asking them to do it.
Yes.
Now it is the same order which is going to be passed. You'll come back again, but this has to
Maybe
be-
I will come back again, but the difficulty is this, my Lord. Only 1 minute of court's time. My Lord, there is a by rotation now. Archakership is given.
You want to argue on
No,
merits?
no.
Then
No,
you
no.
argue. You're free to argue that. You're free to argue on merits. If you want to argue, then we'll not do this.
Having brought it to the notice of the court, it may not be proper.
Yes.
Serial number 7.
ಅದು
Narayan
ಇವರಿಗೆ
Babu.
power ಇಲ್ಲ.
Yes, Mr. Narayan Babu.
One of the petitioner.
Hmm.
And also petitioner had accorded a representation in Annexure J to respondent number 3, my lords. The facts leading to this representation is that the petitioner are the absolute owners of the property bearing survey number 122/3. This came to be purchased by a sale deed dated 23/2/2026, along with a road access, my lords.
Who did the road belong to?
My lords, it belonged to me as well. They had given me a common access to the road.
Who are the owners of survey
My
number
lords, I
1?
just want to take to your lords to page number 38, my lords.
The owners of survey number 122/1, 122/2,
Or my erstwhile vendors, my lords.
121/2 are the same as
Yes, my
owners
lords.
of.
All it belongs to one family members itself.
Hmm.
So I just want to take a lordship to page 38.
Yes.
My lords, I'm the owner of survey number 122/3. It's a 30 feet road, my lords. The other survey number is survey number 133, survey number 121/1, 121/2, 121/1, and
Who is
121.
interrupting the road now?
My lords, these are the other landowners who belong to the same family have entered into a joint development agreement, my lords.
You have to file a civil suit.
My lords, only thing is that we had given a representation, still that has not been
The
considered, my lords.
representation cannot be considered in private lists.
No, I just had given to this STR, they're seeking a approval, my lords, for the layout.
Who is interfering? Who is doing it? Private parties.
That's right.
Don't drag the official respondents.
No, just I saw the representation still till date they are not considered. At least let them pass an order to that effect. That's the thing.
Not
seeking,
necessary. DGA accepts notice for respondent number 1. Shri Yogesh Naik accepts notice for respondent. Is directed to accept notice for respondent number 2 and 3. Petitioner is before this court seeking for the following leaves. The petitioner claims to be the owner of the land in survey number 122/3 of Indlebale village, Attibele Obli, Anekal Taluk. His submission is that the owners of the adjoining land are now proposing to form a layout in their land, and by way of formation of such layout, the access to the land of the petitioner would be affected. And it is in that background that a representation had been submitted to the respondents, placing on record the objections of the petitioner. If at all the private parties are forming a layout and they would interfere with the access to the land of the petitioner, it is for the petitioner to file such appropriate proceedings against them as permissible under law, and not to seek for a representation to be considered by the respondents for non-sanction of the plan. The list is between private parties. The official respondents cannot be dragged into a list between private parties. In that view of the matter, though costs could be imposed on the petitioner, this court refrains from doing so. Hence, the no grounds being made out, petition stands disposed. We are seeing this happening everywhere now.
No. That's the thing. Only that was a common. No, my lord. That's a common. That's a common road. That's the thing.
Get everybody to interfere. Get police people to come and stand. Yes.
Serial number 8, Irappa Reddy.
Seeking for a writ of mandamus to the respondent.
Yes.
Respondent sanctioned 5 crores as loan. In spite of I established industry, I am running industry. Not even a single pay they have released. I gave representations, they were not considered.
What is your representation?
Representations annexure G and H.
What is it? What do you ask for?
See, 5 crores as per exhibit P, annexure A, 5 crores sanctioned. I have installed machineries, I am running the industry. So ಅವ್ರು ಕೊಡ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಮೇಡ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಟ್ಲೀಸ್ಟ್ ರಿಲೀಸ್ ಮಾಡಿ ಅಂತ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ವಿತಿನ್ 6 months ನಾನು ಲೋನ್ ಅವೈಲ್ ಮಾಡದೇ ಇದ್ಲೆ ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ. 11/3 ನಲ್ಲಿ ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು.
ಲೋನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ಲ,
ಮತ್ತೆ
ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಮ್ಗೆ ಅಮೌಂಟ್ 5 ಕೋಟಿ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. 5 ತಿಂಗಳಾಯ್ತು. ಐ ಆಮ್ ರನ್ನಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ, ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ.
Somashekar T.
The Somashekar T is direct to accept notice for respondent. Is direct secure instruction make a submission as regards the representation submitted by the petitioner in the present matter. Released on 8th September.
ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಕೇಳಿದೀನಿ, ಒಂದು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಆದ್ರೂ ಕೊಡ್ಲಿ ಅಂತ.
ನಾವು ಬ್ಯಾಂಕ್ ಅಲ್ಲ,
ಅವರು ಡೈರೆಕ್ಟ್
ಅವ್ರು ಕೊಡಬೇಕು.
Serial number 9, Arjan. Serial number 10, Sunita N.
My lords, the petitioner has submitted a representation on 27/5/2026 as permitted by the division bench of this honorable court, which is in annexure B, my lord. And that representation has not been considered till date. So we seek from this honorable court a direction to consider the representation and pass a speaking order, my lord.
It's only permitting you to raise a grievance as regard running the hospital. It can't be, now your representation is to hand over the hospital.
No, we are not, now we are in our prayer, if you just look at it, my lord, we are deliberately focusing only on the addressing of representation.
Who are you, madam?
I'm the petitioner, my lord.
Who are you?
I'm the insured person.
So you want to run the hospital?
No, I don't want to run the hospital, my lord. Actually, we have, through the representation, we have presented a
Read your para
grievance.
14. Read your para 14.
In order to mitigate the sufferings of the insured person and keeping in mind the paramount interest of
Para
the
14
insured.
of your representation at para 20, page 20. That is what you want to be considered.
Yes, sir.
Read that. This is not what has been directed by the division bench.
In the view of the above facts, the order dated 23/4/2026 passed by the Honorable Court, WP number 9470/2026, steps to hand over the administration of the state-run ESI hospital, Indira Nagar, to ESI and to ensure uninterrupted, efficient and quality medical services to the insured person, my lord.
Where is this direction in the division bench order?
My lord, my only prayer is only to consider the representation, my
This
lord.
is an abuse of the process. Please don't do these kind of things. You are misinterpreting, misquoting, misrepresenting the orders of division bench of this court by submitting these kind of representation.
Apologize, my lord.
There is no such direction which has been issued by the division bench.
Okay. No, we have, through our representation, we have also presented the grievance.
Is there a direction issued by division?
No, not the. The petitioner had filed a PIL, my lord, concerning state-run hospitals. And then the division bench observed that there was a.
What does he do?
He is a retired person now. He's a kidney patient. He has gone through a transplantation as well. So he is not able to get the medical
That is
facilities
the reason why
there.
we'll impose only 50,000 cost.
He's not able to get the medical facilities there, my
Don't
lord.
misrepresent the order of the court.
We'll
That
withdraw.
will not be accepted by this court.
Apologies,
You are
my lord.
misrepresenting the order of the division bench. And you want a mandamus to consider that misrepresentation. Double.
We'll withdraw.
Who do you appear
We'll
for?
withdraw, my lord.
Respondent 3, my lord, R3.
What do you want to do?
I'll withdraw, my lord.
The so-and-so accepts notice for respond number 3.
Lord, I've
And
already
AGA
filed my
for
memo
respond
of
number.
appearance. I've already filed my memo of appearance. My name is not shown.
Accepts notice for respond is number 3. Learned AGA for respond number 1 and 2. Who, after arguing for some time, when it was pointed out to the petitioner that the representation submitted by the petitioner is not in accordance with the orders passed by the Honorable Division Bench on 23rd April 2026 in WP number 9470/26. Counsel for the petitioner seeks permission to withdraw the above petition. Accepting our request, the petition is dismissed as withdrawn. Ask your client not to be doing this.
11. Suprita Kenneth.
Petition in this case, my lord. The second respondent has issued the implement endorsement, my lord, via annexure L, my lord. They insisting to produce the Lavini sketch, my lord. The petition, they are insisting to produce the Lavini sketch, my lord.
Lavini sketch.
Lavini sketch, my lord. The petitioner is a agreement holder, my lord. The one Sri Tirumalas has executed a registered agreement of sale in favor of the petitioner, my lord, on 31/8/2023, my lord. Thereafter, they have not executed any sale deed, my lord. Thereafter, the petitioner approached the civil court, honorable civil court, my lord. Then
a decree has been passed in execution.
Please, madam.
Secure instruction. And secure instructions.
Again means.
Allah, Monday by that order that was passed, now they want to file an appeal. Necessary, my lord, if there is any decision if they take with regard to the court decrees now.
Now there's already an order which has been passed by the coordinate benches.
Yes, ma'am. They are preferring an appeal, I am told, my lord.
You can prefer an appeal on this also.
This also. But then, my
Coordinate
lord,
bench
then-
has passed the order, we are bound
They
to.
will
We
not-
can't
what-
on that ground say that.
Correct, my lord. But what happens is, my lord, in the meanwhile, if they are preferring an appeal, anyway, they will not register the document. If at all they can come with some solution, I'll discuss this. A week's time may be granted, my lord. I will try my, because
There's no
somehow
solution
even
that you
I
can
feel
come up with this.
they have to come up with some solution to this 11E thing, my lord, with especially with the court decrees.
Yeah.
My lord, I am.
We agree with you completely. This is only giving rise to further litigation.
Yes, ma'am.
But that is for the petitioner to understand.
No, I am not coming in the way what the court has already held.
Coordinate bench, division benches held.
Yes, my lord.
Single benches held. We are bound by it. Challenge all these things in an appeal. Even this.
Wait.
In similar set of facts, my lord, this lordship has allowed the same position.
We are bound by the division bench's order. So. And AG accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the document which had been, document being a sale deed, which had been presented before the sub-registrar for registration, was so presented in pursuance of a decree of specific performance in OS number 78 of 2024, and the warrant for registration issued in execution petition number 48 of 2024. On that ground, the counsel for the petitioner submits that the respondent could not have refused registration on account of non-production of 11E sketch. His submission is that the risk of the location of the property and the identification of the property is entirely that of the petitioner.
Please.
And the sub-registrar and or any other government authority would not be responsible in any manner as regards the title of the property and or the location of the property, including the possession of the property. In that view of the matter, this court passes the following order. Writ petition is allowed, a certiorari is issued. The endorsement bearing number so-and-so dated 28/11/25 issued by respondent number 2 at Annex L is quashed. A mandamus is issued directing the respondents to register the sale deed as presented in furtherance of the warrant of execution issued in execution petition number 48 of 2024 within a period of 30 days from the date of receipt of a copy of this order, as per the undertaking, as per the submission and undertaking made by learned counsel for the petitioner.
One more line, there is a submission of a sketch from the licensed surveyor. Let them,
they are not going to do it.
At least something will be on record.
In all these matters, we have seen it coming back with further litigation.
Yes.
Because when they go there after the registration, there's a law and order situation. And they will never be able to identify their property.
Serial number 16 also same, my lord.
Serial number 16.
16 when it reaches.
Serial number 12.
Great.
Proceeding under section 26 of the Karnataka Society Registry initiating a dead person.
Cooperative society.
Annexure demand. The application is available in Annexure X, page number 179.
KSR or KCSR?
KSR.
KSR. Assistant Register of Cooperative Societies.
We have challenged the notice earlier occasion. You last directed me to file an objection, however they order, then if I move the court like that. Then I filed the objection. I raised the question of law without considering the question of law and the facts.
Mysore Society, yes. You made all the Cooperative Society register.
Society Registration Act, 1960.
567 ನೋಡಿ ಯಾರನ್ನ ಮಾಡಿದ್ರ 456
ಅಲ್ಲಿ ಈಗ the Cooperative Society ಗೆ hand ಮೊದಲು ರೆವಿನ್ಯೂ ಇತ್ತು. ಈಗ ಪರ್ಸನಲ್ ರೆಸಿಡೆಂಟ್ ಇದ್ರ ಮೇಲೆ DC ಇವರು Cooperative Society Department they are handling.
All the societies are now being administered by the Register of Cooperative Society.
Yes. I think some notification are there.
Yes.
Millard, kindly see the death certificate, Millard, Annexure T, page 156. That is 31/3/2025.
156.
Yes, Millard, 156. Annexure T. This Nanjunda Swami was died on 31/3/2025.
Yes.
Then, Millard, in 7/5, show cause notice was issued. Annexure U 158, Millard.
Neeware, Nanjun Swami or?
I am the LRs of Nanjun
LRs
Swami.
of Nanjun Swami.
Yes.
Yes. Show cause notice was issued on?
7/5/2025 against the dead person. 161, first name is Nanjun Swami. And second notice, some of the sitting director filed objection on 9/5. Second show cause notice, they notified my death. Page number 169, Millard. The name is available 172. First name is Nanjun Swami. Pauti agid Varasudarari. Then application is filed on Annexure S 179. Again Nanjun Swami. In the proceeding on 26 11, they filed an application for a LR application on 26/11. Then on 3/12, the notice was issued to us. That was questioned before Your Lordship. In writ petition number 15447.
Page?
Page 220, my lord. Your Lordship directed us to file an objection, suffer the order. Then, if appeal is available, you approach the appellate authority. Then I filed an appeal before the KAT. KAT said that the appeal is not maintainable.
We asked you to reply to.
I filed reply.
Not for appeal.
File reply. Reply is available at page number 211. A specific question raised in para number 6 and 7 of my objection. Against LR, no application is maintainable.
KSR Act. Inquiry has been completed.
Inquiry completed without issuing notice. You can explain, so that is a different issue, my lord.
Accepted by the registrar.
Acceptance in order mandilla, undated inquiry report. No date was put in the inquiry report. And it was not communicated to each and every person. And absolutely there is no specific charge against the first respondent or other respondent. Against the general charge is available in the application itself, my lord, at page number 181 ಅಲ್ಲಿ charge 5 charges ಇದೆ. General charges.
Even if the report is accepted, a fresh hearing has to be conducted to fix the
hearing.
responsibility.
That is, I think that is also challenge here. Yes. As far as the scope of 26 concerned, there are 2 judgments.
And AGA accepts notice for respond number 1 to 6, issue notice to respond number 1 to 6 and 8. Administrator idare ivaga 7 ge 1 to 8, issue notice to respond number 9, returnable by 29th September. Considering that that surcharge proceedings under section 26 of the KSR Act 1960 had been issued in further report under section 25 of the KSR Act, the show cause notice, the first show cause notice was issued post the death of the husband of petition number 1
and father of the
father of petition number 2 to 5. The question that would have to be decided is whether a surcharge proceedings could be initiated against the legal heirs of a deceased former officer stroke director of the society. In that view of the matter, the further proceedings
application 1/2025
in application number 1 of 2526 pending on the file of the 5th respondent, he stayed till the next date of hearing.
Much.
Process fee and copies to be furnished by end of day 20th August, failing which the interim order will stand automatically vacated.
Much.
Yuvraj itself consider Madi will have to assist us in this. Even after the report is accepted, whether surcharge proceedings can be initiated against legal heirs or the estate, that you will have to place it.
Actually, Rajasthan High Court Panchayat Raj Act is not maintained.
ಇದ್ರಲ್ಲಿ ಯಾವುದು ಇಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಇದ್ರಲ್ಲಿಲ್ಲ. ಒಂದು
Yes,
only
sir.
determination for liability has to be determined ಅಂತಂದ ಇದೆ 1991 ನಮ್ದು ಹೈಕೋರ್ಟ್.
Cooperative societies ಅಲ್ಲಿ there is a
64 into 69.
it can proceed insofar as the estate ಅಂತಿದೆ. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
If the liabilities is determined when he is alive.
Determination can also be made.
Yes. But
But
he is not
only
a member.
recovery is from the estate,
Yes, sir.
not from the legal heirs.
Yes.
That is what the relation is in cooperative societies. Societies ಅಲ್ಲಿ
In terms of the Allahabad High Court, same view.
we'll have to see that. And
Serial number 13.
a 2 of
submission.
26 is allowed.
13, I'm challenging an order passed by the RERA on two principal grounds. One on procedure, the other on jurisdiction. Please see
Rare or appellate authority?
please, my respectful submission is I fall under the Whirlpool Corporation exception. I just showed to your lordships the procedural impropriety. Could your lordships please see page 29?
Yes.
This is the impugned judgment. Now kindly see the first paragraph itself. For the relief of direction to the respondent to register.
number?
Page number 29.
Uh,
Page number 29,
the
first
complaint is
paragraph.
for relief of direction.
For the relief of direction to the respondent to register the project under so and to follow the terms of the agreement signed by the buyers. This is a relief in the nature of delay period interest under section 18. Now please see para 4. During the proceedings, complainant has requested this authority to amend the prior as refund with interest. Now this, my first submission is, insofar as this amendment is concerned, no application was filed. I was not put on notice. I was not permitted an opportunity to file my objections to the so-called amendment. In fact, we see the daily orders of the RERA also I'm producing before your lordships. Just produce. The daily orders is also conspicuously silent insofar as this amendment is concerned. Please see from page number 43.
Where's your objections filed?
My objections filed, your lordships may please see in the petition paper book at 136. My principal contention over there, which is going to be my second contention before your lordships, is that this project was not an ongoing project at all.
That's a different issue.
On that point also, coordinate bench has taken the view that if it strikes to the root of jurisdiction, this honorable court has jurisdiction to entertain the matter. At 136 para 3, I take the contention that it is not an ongoing
Don't
project.
mix up the submissions. First finish one submission.
Please.
Or
136.
should we give up that, you are giving up the first
No, not
submission?
at all, not at all. Please. I'm just taking your lordships through 136. This is my objections. The so-called amendment.
You said about the delay.
I'm sorry, your lordships.
Where's any, this one on delay?
Delay, your lordships. At para 5, I say that the agreement was entered into in 2013. Then complaint is filed in 2021.
Para?
Para 5, page 137.
Where do you say that it's been completed?
My respectful
Para 5, you only said that agreement has been entered into on 23/8, supplementary agreement on 25/2013.
Please, my submission.
What about completion of the project?
Insofar as completion is concerned, that was my second submission before your lordships, which is that this was always envisioned to be a pure layout project. There was no construction that was required. So therefore, insofar as layout project is concerned, I execute a relinquishment deed in favor of the Arnical Planning Authority in 2010 itself. A commencement certificate is issued by the Arnical Planning Authority stating that they are releasing 60% of the sites. So therefore, on jurisdiction, my submission is that it is squarely covered under sub-explanation 1 to rule 4, which is that if it is a layout project.
60% is not 100%.
Please.
60% is a second tranche.
Yes.
The third tranche of 40% is still to be released.
My respectful submission is this may fall in the 60%.
Where is the third tranche release?
On instructions, I state that after the 60%, nothing else was applied for. So other the release
Not completed. It won't come under the exception.
My respectful submission is, insofar as 60 was released and relinquishment deed was executed, it may fall under rule sub-explanation 1 to rule 4.
Won't come under that until you get the completion.
Please.
OC has to be there for 100%.
Please, my
You
respectful.
can't say I've done part of it, therefore I'm out of it. No.
The extent, I bow down. At least insofar as the extent regulations are concerned, for a layout project, there may be no OC, is my respectful.
There is a OC which is
Under
going
the
to be
Gram
given.
Swaraj and Panchayat Raj Act and the model building bylaws.
See the model building bylaws of
Bylaws.
1995.
Adರಲ್ಲಿ erection of buildings ಅಂತ ಇದೆ. Adರಲ್ಲಿ insofar as layout is concerned.
Layout ಇದೆ. Planning authority no ಕೊಡಬೇಕು. Planning authority also has to give. We have dealt it with another matter.
Please. Now this is insofar as merits is concerned. Insofar as procedural impropriety, my respectful submission is,
Yes.
I ought to have been put on notice. An opportunity should have been given to me. That I've taken a lordships through para 1 and para 4. Now if a lordships may just take the impugned judgment again for a moment, please see para 6 to 12. 6 to 12, the authority extracts my contentions from the statement of objection. That is at page 31. At page 31 from para 6 to 12, he extracts my contention insofar as the statement of objections is concerned. Then if a lordship sees at page 38, in para 27, it is pertinent to note that in response to the notice, the respondent has appeared before this authority, but has not contested the matter by filing statement of objections, producing documents in his behalf. The claim of the complainant remained undisputed and unchallenged, which is corroborated with cogent evidence. Hence, no option left to this authority but to accept the claim. Now, I have filed my statement of objections. He records it from 6 to 12.
Where is it recorded in the order sheet?
Please, in the impugned judgment itself at page 31. Please see para 6. After registration of the complaint, in pursuance of the notice, the respondent has appeared before the authority through his authorized signatory, contested the matter by filing objections. King ಹೇಳ್ತಾರೆ.
Where is Mr. We are not going to state.
Can I make one submission, one suggestion? I understand it's a money decree. 50% I'll deposit before that.
Issue notice to respond number 1. Counsel for, he appeared through his counsel. Counsel for the petition is also permitted to serve the counsel who appeared for respond number 1 before the Karnataka Real Estate Regulatory Authority. Shri Gautam Dev Ullad for respond number 2. The submission of learned counsel for the petitioner is that the petitioner is ready to deposit or pay.
I'll deposit 50% before I
I don't
launch.
want your money. Give it to them. They need the money.
Then liberty may be subject to the outcome of this.
He will make payment of 50% of the amount awarded under the impugned order dated 7th November 2025 in CMP/UR /210,408/0007876 within a period of
8 weeks.
8 weeks from the date of from today. That is on or before. Do 50%, 25% in 4 weeks and 25% in another 4 weeks.
Yes.
Okay, within 8 weeks. The first tranche of 25% in 4 weeks from now, that is on or before 16th September, and the second tranche of the remaining 25% by 14th October. In that view of the matter, the operation of the order dated 7th November 25 in so-and-so is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 20th August. In acknowledgement of service of notice on respondent number 1 to and the counsel of respondent number 1 who appeared in the before the Karnataka Real Estate Regulatory Authority to be filed in the registry of this court by end of date 25th August, failing either of which the interim order will stand automatically vacated.
Maybe needless to state, but that deposit may be subject to
the payment of the monies to respondent number 1 shall be subject to the result of the above petition.
I'm great.
14, Poonam S. Patil.
Yesterday's
Similar,
matter,
yes,
madam?
connected matter, my lords. This is.
Connected matter. When has that gone to?
That is on 28th August, your lordships.
Connect with learned AGA accepts notice for respond number 1 to 3. Connect with so-and-so and relist on 28th August.
Please.
Serial number 15.
Similar direction, my lords. Similar direction.
Same order as in that.
Please. So slip code.
Number could you?
I will just.
Yes, Mr. Rajesh.
for the petitioner, my lord. My lord, petitioner is the promoter of the guarantor of certain loans, and he was declared as a willful defaulter, my lord. My lord, I should say at the outset that the NCLT, my lord, the lending agency has declared him, sought to declare him insolvent, which he was declared insolvent, and he has gone on appeal before the NCLAT, and NCLAT have directed them to reach a settlement. This is a loan, my lord, which he
IDBI is a party there.
Yes, my lord. These are three banks, my lord. IDBI, I see.
Who is appearing for IDBI there?
There, IDBI. I'll just. Before NCLT, my lord, I'll just.
Same council will direct.
No, Bangalore. I'll just furnish them.
Shri so-and-so is directed to accept notice for respond number 1. Shri Pradeep Sauka for respond number 2. And ASGI for respond number. Ms. Swamini Mohanambal for respond number 3. Union of India Financial Services. Counsel for the petitioner to furnish 2 sets of the petitioner along with annexures on the said councils. When is the matter posted there?
My lord, in NCLAT, it's posted for.
NCLAT?
NCLAT, my lord. NCLT has declared him to be insolvent. He has gone on appeal to NCLAT. NCLAT has directed him to, on 17th August was the last date. I'll furnish the next date.
When to post this?
My lord, next week, my lord.
Unnecessary. If there's in September, why should
2 weeks, my lord.
Give us a date.
I'll give the date, my lord.
A date admele.
Not only one request, my lord, as per page 60, because they have declared me as a willful defaulter, because Canara Bank and State Bank declared me as willful defaulter. I've challenged State Bank, my lord, in a companion petition. Here they are saying that they will issue a photograph, my lord. That could be, my lord, stop.
That publication.
Yes, my lord.
Page 60. The matter is pending for amicable resolution before the NCLAT in so-and-so.
Yes, my lord.
The respondents are restrained from publishing the photograph of the petitioner in the website or the newspaper till the next date of hearing.
Grateful, ma'am. I'll just furnish the details.
Furnish the name and number.
Grateful, ma'am.
If you don't settle, then we'll withdraw the interim order.
Please, ma'am. My lord, so far as the main interim, the willful defaulter classification, I've raised issues on procedure, but the NCLAT has directed me to offer a proposal. That, yes.
Serial number 16, Subrita KH.
16.
Ms. Suprita.
No, 16 is same matter, but disposed.
Same serial number 11.
Right.
16 same 11. Case number change agat.
17.
Here for the petitioner, Recreation Club back.
DGA for the respondent, the benefit of the interim order in so and so will be applicable, is extended to the benefit of the, is extended to the petitioner. Connect with so and so and relist on
27th of
7th September. As 27th?
Oh, yes,
September or August?
No, this month.
August.
18. Ravi H.
Yes, Mr. Kantraj? Yes, please.
Lord, petitioners, Lord, they want to appear for the probationary examination, gazetted probation officers. Lord, the response, see, Tahshildars are rejecting to issue the caste certificate, saying that their income is, say, more than 8 lakhs. And while issuing the endorsement at Annexure CA and BC, the Tahshildar has taken into consideration the income of the petitioners. But the Supreme Court has already come to conclusion saying that the parents' income has to be taken into consideration.
Where is the judgment?
Annexure.
Produce madidira?
Madid.
Page?
You last me kindly see. Annexure Q, page 77. Page 77.
77.
Subsequently, that judgment has been followed in several cases by our high courts.
This is Supreme Court judgment.
Yes, sir.
And AG accepts notice for respond number 125. KPSC error.
Mohammed Shamil.
Mohammed Shamir for respond number 6. The grievance of the petitioner is that while considering the issuance of a income cum cash certificate in favor of the petitioner, the income of the petitioner is also being taken into consideration, which could not have been so considered in view of the decision of the Honorable Apex Court in AR 2015 SC 537, wherein it has been categorically stated that it is the parent's income alone which is required to be taken into consideration. In this case, the petitioners being in-service candidates, their income in service could not have been taken into consideration. Submission by Sri Kantraj, Learned Counsel for the petitioner. The said submission is borne out by the dicta of the Honorable Apex Court in Surinder Singh Supra. Hence, the respond number
6 May. 6 May. KPSC may be directed to receive the application.
You are really consider and issue your certificate.
31st certificate
Can be produced there.
31st is the last
that
date
we will
for-
produce, Malad. That we will produce.
This will cause a lot of confusion, this prayer that you sought for.
Now, Tashildar will have to issue the certificate, non-creamy layer certificate, annexure.
Mr. Kantraj, as it is, KPSC functioning is, if you confuse it even more like this, not only you, a lot of other people will suffer.
Tashildar may be directed to issue the non-creamy layer certificate.
In that view of the matter, the petitioner is before this court seeking for the following reason. In that view of the matter, the District Caste Verification Committee is directed to consider the above observation and the decision of the Honorable Apex Court in AR 2015 in Surinder Singh's case and issue necessary income cash certificate of the petitioner without taking into consideration the income of the petitioner, but only taking into account the income of the parents of the petitioners.
In forms H, Malad.
In Form H, within on or before 25th August 2026, which the petitioner would be entitled to submit to respond number 6, the last, before the last day.
31st, madam. 31st is the last.
How to?
By 25th, if they give it, then
Direction is to Tashildar. Malad.
DCBC. Tahsildar ಹೆಂಗ್ ಕೊಡ್ತಾರೆ?
76 ಅಲ್ಲಿ there is a format.
ಅಲ್ಲಲ್ಲ 76 ಅಲ್ಲಿ ಫಾರ್ಮೆಟ್ ಇದು ಕೊಟ್ಟಿದ್ದೀನಿ ಪೇಜ್ 76 ತಹಶೀಲ್ದಾರ್ ಇಶ್ಯೂ ಮಾಡೋದು ಸುಮ್ಮನೆ.
Who is the authority, DCBC or
ಇಲ್ಲ ತಹಶೀಲ್ದಾರ್.
the respective Tahsildar,
Tahsildar.
only respond number 3 to 5 are
Yes.
directed to issue in Form H
Right.
by 25th. ಇದು ಬೇಗ ಟೈಪ್ ಮಾಡಿಕೊಟ್ಬಿಡಿ.
Same should be accepted by KPSC because they are insisting on
Serial number
Form F.
19.
And the same shall be accepted by Milad KPSC.
To on or before the last date
ಅಲ್ಲಲ್ಲ
ಅಂತ ಹೇಳಿದೆ. Will be entitled to ಅಂತ ಹೇಳಿದೆ.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಫಾರಂ ಎಫ್ ಆದ್ರೆ ಆರ್ ಡಿ ನಂಬರ್ ಬರುತ್ತೆ, ಹೆಚ್ ಎಲ್ ಆದ್ರೆ ಆರ್ ಡಿ ನಂಬರ್ ಬರಲ್ಲ. ದೇ ಆರ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಫಾರ್ ಆರ್ ಡಿ ನಂಬರ್. ದೇರ್ಫೋರ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸೇ ಮಿಲಟ್ KPC shall accept ಫಾರಂ ಹೆಚ್ ಅಂತ issued by the ತಹಶೀಲ್ದಾರ್.
Sorry, what is that submission? Form H ಆದ್ರೆ
ಫಾರಂ ಹೆಚ್ ಆದ್ರೆ ನಾನ್ ಕ್ರಿಮಿ ಲೇಯರ್,
ಹಾ,
ಅಲ್ಲಿ ಇನ್ಕಮ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಇನ್ಕಮ್ ಬರೋದಿಲ್ಲ, ಅದನ್ನ ಫಾರಂ ಹೆಚ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. ದಟ್ ಶಾಲ್ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ಬೈ ದಿ KPSC.
why are you restricting it to form? I mean, as per the applicable
ಫಾರಂ
rules.
ಎಫ್ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಆರ್ ಡಿ ನಂಬರ್ ಇರುತ್ತೆ, ಇದ್ರಲ್ಲಿ ಆರ್ ಡಿ ನಂಬರ್ ಇರೋದಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಆರ್ ಡಿ ನಂಬರ್ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದಂಗೆ ಫಾರಂ ಹೆಚ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದ
Form F ಅಲ್ಲಿ ಕೊಟ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ?
ಫಾರಂ ಹೆಚ್ ಕೊಟ್ರೆ ಆಯ್ತು.
F ಕೊಟ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ಎಫ್ ಕೊಡ್ಬೋದು.
ಮತ್ತೆ why are you insisting on H?
ಎಸ್ ಎಫ್
Form H ಬೇಡ in the applicable form.
ಎಸ್ ಎಸ್ Great.
ನೀವೇ ಹೇಳಿದ್ದು ಫಾರ್ಮ್ ಹೆಚ್ಚು ಅಂತ.
ನಾನೇ
19. CH-10 Balakrishna.
Yes.
Lords, this petition is with respect to the interest subvention scheme, my lords. Interest subvention scheme, the petitioner is availed two loans, my lords. There are two tripartite agreements and there are two agreement to sale. Annexure A and C, my lords.
ಅದು ಯಾವ್ದು ಉನ್ನಿಕೃಷ್ಣನ್ ಯಾವ್ದು ಹಾಕಿದೀವಿ ಅದು?
Unnikrishna.
And Sri Unnikrishan for respond number 1 and 2. Pradeep Savka for respond number 3. Sukanya Baliga for 4. Velankani Ravi for respond number 5. State Bank of India Shetty alla. Vignesh Shetty for respond number 6. IDBI.
DP Muttanna.
TP Muttanna for 7. Issue notice to respond number 8. Written by Adyavat or direction kottidivalla to get back on. Written by so and so. The respond number 6 and 7 are restrained from taking any coercive steps against the petitioner for recovery of any EMI till the next date of hearing. This is of no use to you. You have to go before the RERA. Connect with so and so.
2nd September.
And delivery. And delivery. 18 and delivery.
Petroleum agency.
ಬರ್ತಾರೆ 5. ಡಿಸ್ಪೋಸಲ್ ಅಲ್ವಾ? ಡಿಸ್ಪೋಸಲ್ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರ?
ಮೊಹಮ್ಮದ್ ಶಾಮಿಲ್ಗೆಲ್ಲ ನೋಟಿಸ್ ಮಾಡಿದ್ರು.
ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್
ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಆರ್ಡರ್ ಅಲ್ಲೇ ಬಂದ್ಬಿಡುತ್ತೆ, ಅದೇನು ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಮ್ಯಾಮ್.
ಅಪ್ಲೈ ಮಾಡಕ್ಕೆ ಅಟ್ಯಾಚ್ ಮಾಡಬೇಕು.
ಈ ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆಲ್ಲ ಅಲ್ಲ, ಅದಕ್ಕೆ ಒಂದ್ಸತಿ ಓದ್ಕೊಳ್ಳಿ ಅಂತಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ವಲ್ಲ, ಓದ್ಕೊಂಡು ನಂದಿದೆ. ಲಾಸ್ಟ್ ಇದೆ 121. ಏನ್ ಡೇಟ್? ನಾವು 11 ಕೊಟ್ಟಿದ್ದೀವಿ. 11 ನನ್ಗಿದೊಂದು ಏನ್ ಗೊತ್ತಾ, ನನ್ನ ಫೈಲ್ ಎಲ್ಲೋ ಹೋಗ್ಬಿಟ್ಟಿದೆ, ಎಲ್ಲ ಏನೋ ಚೇಂಜ್ ಆಗ್ತಿದೆ. ಅದನ್ನ ನನ್ನ ಫೋಲ್ಡರ್ಗೆ ಹಾಕೊಡ್ಬೇಕು, ಹಾಕಕ್ ಬರುತ್ತಾ? ಎಲ್ಲೋ ಹೋಗ್ಬಿಟ್ಟಿದೆ. CD ಡ್ರೈವ್ ಅಲ್ಲ, ಸಿಕ್ತು ನನ್ಗೆ ಎಲ್ಲಿ ಅಂತ. ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಹಾಕೋಬೇಕು. ಯಾಕಂಗ್ ಮಾಡಿದ್ರು ನಿನ್ನೆ ಏನೋ ಫುಲ್ ಚೇಂಜಸ್ ಎಲ್ಲಾನು ಫುಲ್ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಅದೇ ನನಗೆ ಅದೇ ಇಲ್ಲಿ ಫುಲ್ ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ನಿಮ್ಗಳಿಗೂ ಹಿಂಗೆ ತೊಂದರೆ ಆಗಿದೆಯೇನೋ? ಎಲ್ಲೆಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ನಾನು ಬೆಳಗ್ಗೆಯಿಂದ ತಲೆ ಕೆಟ್ಟೋಗ್ಬಿಟ್ಟಿದೆ. ಬೆಳಗ್ಗೆಯಿಂದ ನಂಗೆ ತಲೆ ಕೆಟ್ಟೋಗ್ಬಿಟ್ಟಿದೆ. ಸರಿ, ಅವರೇ ಮಾಡ್ಬೇಕಾ? ಈಗ ಈಗ ಅವ್ರ ಅದನ್ನ ಮಾಡ್ಸ್ಕೊಂಡು. ಫೋನ್ ಮಾಡ್ತಿದ್ದೆ ಯಾರು MGS? ಅವರು ಓದ್ಕೊಳ್ಳಿ, ಅವರು ಓದ್ಲಿ, ಅವ್ರಿಗಾಗಿರೋ ಆರ್ಡರ್ ಅವರು serial number 20 urgent, serial number 21 Satish K.
Yes, Satish.
Lord, the petitioner was working as my lord sub-registrar at Tavrekere. Lord, the fourth respondent applies for Lord Information and Right to Information Act. Lord, the information is furnished at Annexure F, my lord, page 54. That, my lord, khata is not obtained while registering the sale deed. Lord, the Information Commission, the impugned order is at, my lord, Annexure H, page 57. Orders.
How did you register it without a khata?
Lord, is the, my lord, at the relevant point of time, Annexure B, my lord, is the information sought.
When was it registered?
2019, my lord.
You are the.
I was the sub-registrar.
You are the SR.
I have registered. I have registered. The present sub-registrar gives an information that khata is not available along with the sale deed, which my lords will find at page 54. But the Information Commission orders for an inquiry and to submit the report at page 57 on the ground that sale deed is illegally registered. Therefore, hold an inquiry against the sub-registrar, which is
say inquiry only,
but which is beyond the scope of my lord commission.
Section 22, obviously it can be done.
Please.
Section 22 plus subclause 2 of section.
Lord, this honorable court has held that Lord, commission cannot order for only in respect of information sought. If information is not given, Lord, commission can hold a direct to hold an inquiry. That is not the direction. Lord, kindly take page 57.
So we'll direct the Secretary Revenue to initiate those proceedings.
But your lordship may kindly appreciate.
We'll hold that it is not the KIC, but the Secretary Revenue who was free to
khata,
do so.
Lord, khata cannot be Lord insisted. Is page 69 for a moment. This honorable court has held that the purchaser need not produce the khata for the purpose of registration. Page 69, Lord. And sub-registrar cannot insist. The sub-registrar cannot insist on production of khata for admitting a document for registration. He cannot also refuse registration if the khata does not stand. But relying upon my lord rule
2006, that
not 2006, my lord, 2018 judgment. Page 58.
Proceedings in 2006 when the rules were different. Subsequently, rules have changed.
2019.
Now, without e-khata, now you can't register anything.
That is, my lord, 2022, my lord.
It keeps on changing.
I have registered in the year 2018.
Here, the registration was in 90s. No facts, no. The registration of the sale deed was that was much earlier, before all these rules were initiated.
But khata
in 1989. Because the law as on 17/5/89 was applied in that judgment, not the law as on the date of when you registered.
At any rate, commission cannot
that is fine. Then that's why we'll say it is the Secretary of Revenue who can do it, or the IGR, who is respond number 2.
But may I request this?
And AG accepts note Sri KIC K. Rajshekhar for respond number 1. And AGA for respond number 2 and 3 issue notice to respond number 4 return out by 28. The submission of Law and Counsel for the petitioner is that the Karnataka Information Commission could not have directed an inquiry into the registration of a document. At the most, it could have only looked into the aspect of whether there is the document which had been sought, documents or information which had been sought for under the Right to Information Act had been provided or not. the substance in the submission made by the counsel for the petitioner, inasmuch as that aspect could only have been looked into by second respondent and or the Principal Secretary of Revenue, who is the departmental head of respondent number, the petitioner, who was the then sub-registrar. In that view of the matter, the further proceedings in pursuance of the direction issued by the first respondent, while order dated 27/7/26, at Annexure H is stayed till the next date of hearing. The stay granted in this proceeding will not come in the way of respondent number 2 or the Principal Secretary of Revenue Department taking any action as may be deemed just by them.
But that last portion may not be.
ಆಮೇಲೆ ಇದನ್ನು misinterpret ಮಾಡ್ತೀರಾ ಬೇಡ.
But
1 of 26 is allowed.
But may I request for hand delivery of the order for the reason that they are moving for suspension of the petitioner.
You're required to be. You're taking a technical objection. All these things, you register documents where they have no right to register and create more litigation. ಕೇಳಿ ಎಲ್ಲ ಲಾಯರ್ಗಳು ಹೇಳ್ತಾರೆ ಸಬ್ ರಿಜಿಸ್ಟರ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಕ್ಕೆ ಎಷ್ಟು ಲಿಟಿಗೇಷನ್ ಆಗುತ್ತೆ ಅಂತ. ನೆಕ್ಸ್ಟ್
Serial number 22.
But
Teshgiri Rao.
hand delivery of the order.
And delivery.
Notes for the petitioners, my lords. Kindly pass over, my lords.
Pass over.
Much obliged.
23.
I appear for the petitioner's counsel. In this case, after number of applications to the KIDB, I was allotted 5 acres of land. Kindly see Annexure B. Annexure B confirms the fact that confirmatory letter of allotment was issued on 19/12/2020 for 5 acres. Payment was received to pay 3,67,50,000.
Unfortunately, you made an application for a very in-demand park.
There was a case.
Kept your other land vacant. This is where all these litigation come.
There was a case. In fact, my lord, there was a case pending before the Supreme Court. Now, my lord, that has been, my lord, decided. Now the acquisition, my lord, has been upheld by the, my lord, the Supreme Court.
So you won't allot land when there's a suit pending and challenge. You make that submission, we'll record it.
Not on that, my lord. 28(4) was
That is
set
this-
aside. That case, writ petition, where, my lord, the landowners had challenged the acquisition proceeding. 28(4) was set aside. That is the, my lord, problem. 28(4) is real, of course.
You want us to call for all the records of this park? On the date on which it has been. Don't give us all these things, your submissions. If it is made under instructions, then we will all up that person.
Not on.
If it is without instruction, then what do we do?
Next.
The KDB requires to be closed down if they are going to be making these kind of submissions. This is a person who has paid 3,68 lakhs.
They paid.
And he is a person who wants to start an industry, and this is how you treat him.
In fact, we have allotted 1 acre, 13 guntas already, not out of 5 acres.
We'll call for all the details on the basis of your submission. When you allotted, to whom you allotted, when the suit proceedings were filed.
Rashmi, kindly take, my lord, page 20. I request, my lord. That is, my lord, the sketch.
Yes.
If private land anta ideyala, that was, my lord, under litigation. That, my lord, the entire extent. There was a, my lord, challenge to the acquisition proceeding. So, my lord, this plot, my lord, was, my lord, suppose, my lord, was required to be allotted, my lord. That is plot number R1B. ಮೇಲ್ಗಡೆ ಡಿನೋಟಿಫೈ ಆಗಿದೆ, ಅದ್ರ ಕೆಳಗಡೆ ಇರೋ ಪೋರ್ಷನ್ ದಟ್ ವಾಸ್ ಲಾರ್ಡ್.
Did you allot R1B?
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
R1A?
R1A ಬೇರೆಯವ್ರದ್ದು ಸ್ವಾಮಿ, ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ. ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋದು ಬೇರೆಯವರು.
And how much
more
is,
clear, my lord.
How much is the extent of R1B?
R1B, my lord, it is. No, my lord, the
May I
exact.
show
extent,
this,
my
my lord?
He knows where it is going.
Lord, all I'm requesting is they are going to allot the rest of the area to third parties. Let them not do it, my lord. Let them consider my prayer, my request. My payment is there from 2020. ಬೇರೆಯವ್ರು ಕೊಟ್ಟು ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಈಗ ಜಾಗನ, ವ್ಯಾಪಾರ ಆಗ್ತಾರೆ.
ಇದುವರೆಗೂ litigation ಇದೆ ಅಂತ ಇವ್ರಿಗೆ you want to allot it to somebody else.
ಈ ಮೊನ್ನೆ
ಜುಲೈಯಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
produced my lord the SLP order, page number 28. Recently it has been my lord decided by the.
So why are you allotting it to third party?
Not allotting it. I don't know what who gave that.
No, we have got authentic information.
We'll accept that. When will you give it to him now?
Instruction. I'll take instruction.
Instructions ಇಲ್ಲದೆ ನೀವು ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ದೀರಾ ಹೇಳಿ.
Next.
When will you give it?
Next week.
Next week you will allot it.
Kindly have the matter next.
When will you allot it?
Part.
We'll stop all allotments in high-tech defense and aerospace park.
ಯಾವುದು ಉಳಿದಿಲ್ಲ ಎಲ್ಲ.
If you know, this must be some 40th or 50th matter that you are appearing before this court in this park. You are appearing or Vasudev is appearing. So many matters in this park. And everything that what Mr. Lokre said. You are now allotting it to some third party. And AGA accepts notice for respond number 1. Accepts notice for respond number 2 and 3. The respondents are restrained from allotting any plot in what is this park called?
Huvinayakanhalli village.
High-tech defense and aerospace park, Bengaluru till the next date of hearing.
ಅದರಲ್ಲಿ
Relist on.
Next week Andhra Swami.
Relist on 27th August.
Much of it.
Okay, we restrain them from allotting any plot in that.
Lord, restrict my lord, I request my lord only for this one. This survey numbers at least. Otherwise my lord. ಮತ್ತೆ ಕಂಟೆಂಟ್ ಅದರಲ್ಲೊಂದು ಕಂಟೆಂಟ್
ಅವಾಗಲೇ ಬರ್ತಾರೆ.
ಈ ಸರ್ವೆ ನಂಬರ್
There is one small plot. You have enough and more to fry there. So
Lord, the lands involved in Lord the SLP that may be clear. At least ಅಷ್ಟೇ.
This court would also have to consider the allotment which have been made in the said park over a period of time since the submission made is that proceedings have been pending before the Honorable Supreme Court. No allotments have been made.
No, only in the respect of this particular survey
Hence,
number.
the respondents are directed to place on record the details of all allotments made. Vis-a-vis, as also the details of the proceedings which had been filed and orders passed before various courts, including the Honorable Supreme Court. We'll match it, then you will know, then we'll take action. Next.
24.
In the fresh matters.
Preliminary hearing.
Fresh 2:30.
ನೀವು ಜಾಸ್ತಿ ಇದು ಮಾಡಬೇಡಿ. Yes, Mr. Order.
My lords, I appear on advance notice for R1, 2 and 4, my lords.
R1, madam.
R1, 2 and 4.
R1 is marketing practices, Department of Pharmaceuticals and Register of Companies.
Please, my lords.
Submit that she would be appearing for respond number 1, 2 and 4. What about 3?
My lords, Mr. Dilip will appear, my lords. Dilip M.
Mr. Dilip is directed to accept notice for respond number 3. Yes, Mr. Order.
Page 482, my lord, if your lords has come to, the same order has been stayed by the Delhi High Court. Can I request your lords, my lord, volume 2, page 482.
Yes.
Please come to my lord, running page 489, para 22.
Yes.
Para 22. Accordingly, the operation of the impugned order dated 23/12/2024. That's the annexure A. Insofar as directs initiation against the petitioners herein shall remain stayed during the pendency of the petition. Gujarat High Court has also my lord passed a similar order at page 491.
This is filed by Kiran Ninad.
Yes, my lord. That's my lord. What has happened is they were all, my lord, the health professionals. We had taken them, my lord. We had to train them. So we had taken them to, my lord, conference. That, my lord, on an anonymous complaint, my lord, proceedings have been initiated.
What are the allegations?
Allegation is that, my lord, we ought not to have, my lord, taken them, my lord, to the conference at our cost. That's the allegation.
So the proceeding against the doctor has been stayed.
Correct, my lord.
How do you get the benefit of that?
My lord, same order.
You are the person instrumental in taking them.
Can I persuade your lordship? Look at my lord, page 62.
62.
Yes, ma'am.
Yes.
On May 21st, Department of Pharmaceutical received an anonymous complaint. Based on that, my lord, they proceed. Can I now request your lordship, my lord, just look at where are the rules? Anonymous complaint cannot be, my lord, entertained. Nodi?
Insofar the doctors, we understand.
Yes, my lord.
That the doctors have been.
My lord, here
asked
what
to
has
come
happened, I'll
and
tell you,
attend
lordship,
the
why, my lord, we had
conference and everything.
ROC, my lord, starts initiating notice, proceedings. SEBI initiates. Every day, my lord, morning, my lord, proceedings are initiated based on this.
Why did you call all the doctors?
My lord, my submission to your lordship is, I've taken them, my lord, because we do this Botox and all that kind of, my lord, beautification program. They have to be trained because even an injection, my lord, it's not like an ordinary injection which has been given.
Is it for training or what?
Yes, my lord, training.
This is under the guise of conferences.
My lord, in the
Training is a
conference,
different
two,
aspect.
my lord, two of them were, my lord, speakers. The others, my lord, were also, my lord, to be trained. If your lordships come to, my lord, the notification, the rules, anonymous complaint can't be entertained. Page 42, my lord, of the
42
of, my lord, not the petition, but this. What I had, oh, sorry. There is what is known as, my lord, Uniform Code of Pharmaceutical, my lord, starts at page 46 or 36. Please come to 42. 10.3. Complaints must be in writing. In each case, the complainant should identify himself with a full mailing address, identify the company which is alleged, give details of the activity, all that. And para 10.4 only, no anonymous complaints made without prescribed fee will be entertained. No anonymous or pseudonym complaints or those made without prescribed fee will be entertained.
Where are we reading?
10.4, my lord, page 43.
Point non-refund or respect.
Adaito. Last line, my lord.
No pseudonymous or anonymous in all those mail.
Shall be entertained. Here, my lord, on the basis of the anonymous complaint, they have initiated proceedings.
We'll have to ask them to delete this line.
That's why, my lord, Gujarat High Court granted
Fine,
stay.
madam.
Delhi High Court granted stay.
My lords, your lordships may kindly see the prayer, my lords. The prayer is insofar as Annexure A is concerned, which was passed in 2024. Annexure B, my lords, is directed against NMC. They don't have any power over this healthcare company, and the doctors have themselves taken stays, my lords. C is a general restraint order against
My lord,
any
your lordship will not grant an order of stay of A.
my lords,
Annexure
I'm
A.
only, my lords, then kindly see, your lordships may also kindly see the operative portion of the order at
Interim order,
65.
my lord, if your lordships turn to, my lord, page
Let her
59.
complete, then we'll come back to you. Yes.
My lords, kindly see at page, my lords,
Where?
that's the page 65, my lords. Page 65, which is the operative portion of Annexure A. Apex Committee reprimand so-and-so, copy of this order to be published on the website. My lords, this order was passed in 2024. Then kindly see operative portion number 2, my lords, that's directed at CBDT. They have to answer as to what action they've taken. There is no specific action of the CBDT challenged in this petition. Kindly see number 3, NMC to take action, which the concerned healthcare professionals have taken the stays, my lords. My only submission to your request is to kindly give me an opportunity to file objections, since there is no imminent threat that has been demonstrated by them, my lords, considering the operative portion of this order. If they say ROC is taking action, SEBI is taking action, my lords, ROC action not placed on record, not challenged. A blanket injunction against statutory bodies from taking action. Kindly see, my lords. Prayer C. Restrain respondents, officers, agents, etc. from taking action, my lords. There can't be a blanket stay against ROC taking action unless they're able to demonstrate what action has been taken and whether it's outside the jurisdiction. Then, my lords, national and state medical councils don't have jurisdiction over this healthcare company, my lords. Therefore, that prayer does not arise here. And secondly, NMC is not a party here. Stay, my lords, to stay
What
annexed
is
to A, my
Annexure
lords,
double A? Yes. Stay annexure A or double A?
Yeah, my lord.
A. And
My lords,
here
I'm only saying since
in
it's
prayer
from
2, you say
2024.
double A and double D.
Interim order is at page 59.
Annexure A is 24.
Correct, my lord.
December 23rd.
Correct.
Let them file their objections.
Gujarat High Court, my lord, in 2026, my lord, state it.
My lords,
Same.
that is, my lords,
Where
if
is
it's
Gujarat?
already
Please come to my lord,
stored,
page.
then my lords,
Please come to my lord, page 500, 482. No, Delhi High Court, 482 at 489.
That is against the doctor as regards NMC.
Correct, my lord.
That is
In
understandable.
2026,
That
in
we
respect of
understand.
this very,
But that is because proceedings were initiated by NMC subsequently.
my lord,
and my lords,
annexure A
doctors
is
are not
state
a party here.
482 at
Annexure A is-
489.
What is stated by the Delhi High Court?
My lord, the annexure A, my lord,
Then why do you want another stay of annexure A?
para 22.
Yes.
In so far as the petitioner ಅಂತ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. Same thing, my lord, Gujarat also,
Order dated 23/12.
2024. That's the same order, annexure A.
Insofar as direct initiation
Correct.
of action, that is by the NMC.
That's all, my lord, that we are also asking, my lord. Page 491, that Gujarat High Court, same.
NMC is not taking any action against you. NMC is taking action
My
only
lord,
against the
question
doctors.
is, my lord, for your lordship's consideration, subject to my being corrected. Can, my lord, on the basis of, my lord, this annexure A, initiate proceedings? If they are independently initiating proceedings, I have no problem.
But
That's all that I'm saying.
You're coming to court after 2 years. At
Only
this
thing
stage,
is-
how do we grant interim order after 2 years? And that is not we always.
I leave it to your lordship, my lord. I don't want to say
Their
anything more.
objections, they are only asking.
Only
time
thing
for
is, no,
objections.
no, I understand. I understand. Only thing is, give a shorter date is all that I can say, my lord. More than
That
that,
you
I
can
don't want to
always
say
say.
anything more.
That you can say that.
My lords, may I request for 28th, my lords?
Ms. B.G. Nayantara learned transfer for respond number 1, 2 and 4.
1, 2, and
6 for and is granted.
my lords, may I request for
How much time, madam?
28th, my lords?
Short time.
28th, 28th.
A week's time to file a statement of objection, get ready and address the arguments. Released on 28th August.
Can it be on 27th if it's not inconvenient to my learned friend?
27th.
My lords,
27th because
27th,
28th.
I'm not in station, my lords, therefore I requested
All
for
right,
20.
all right, my lord, I leave it to that. Because I had to go to a college, law college for a lecture. It doesn't matter, my lord. I'll try to come. my lord.
29th is also a
No, no,
working day.
it's all right. I'll be here.
29th
I'll be here,
working
my
day,
lord.
Very well, my lords, 29th is also.
29th is also a working day.
Please.
29th.
Now, idre.
Now with. Hello.
Only thing is, my lord, I don't want NMC and others to take coercive steps. ಅಷ್ಟೇನೆ.
NMC can take against the doctors.
ನಮ್ಗೂನು ಅಲ್ಲಿ ROC, my lord,
ROC is different.
my lord, on the basis of this, not my lord separately.
But ROC has they initiated any action?
They issued notices. I've produced it.
Yaudu.
Please come to my lord. Running page, second volume.